Hello there, I'm Isaiah Mann, and today I'm going to read you the entire Chapter 14 from Thomas E. Patterson's The American Democracy, 10th edition. Keep in mind that I may become short of breath, change accents in between, or just pass out from the sheer impressiveness of the book. Also, keep in mind this video will be very suited to a bedtime story, for you will find the text incredibly soporific. Look it up. And without further ado, Chapter 14 of The American Democracy. Through its ruling in Citizens United versus Federal Election Commission 2010, the Supreme Court opened the door to unrestricted corporate and union spending in federal election campaigns. At issue was a provision of the 2002 Bipartisan Campaign Reform Act that banned corporations and unions from using organization funds to pay for broadcasts or other advertisements that were designed to promote a political candidate. The ban applied 30 days before a primary and 60 days before the general election, and extended a century-old policy of limiting election contributions by economic organization on grounds that such spending would give them undue influence with lawmakers. A majority of the Supreme Court justices saw the issue differently than Congress had, concluding that the spending restriction infringed on the free speech rights of corporations and unions. Writing for the 5 justices in majority, Justice Anthony Kennedy said, "If the First Amendment has any force, it prohibits Congress from fining or jailing citizens, or the association of citizens, for simply engaging in political speech." Kennedy went on to say, "When government seeks to use its full power to command where a person may get his or her information, or what distrusted source he or she may not hear, it uses censorship to control thought. This is unlawful." The 4 justices in the minority took issue with this argument, saying that allowing powerful corporations to spend freely on elections could corrupt the political process. "While American democracy is imperfect," Justice Paul Stevens wrote, "few outside the majority of this court could have thought its flaws included a dearth of corporate money in politics. The court's ruling threatens to undermine the integrity of elected institutions across the nation." Stevens added that the First Amendment was intended to protect the free speech right of individuals and not of corporations or unions. The court's campaign finance ruling illustrates 3 key points about court decisions. First, the judiciary is an important policy-making body. Some of its rulings are as consequential as a law of Congress or an executive order of the president. Second, the judiciary has considerable discretion in its rulings. The Citizens United decision was not based on any literal reading of the law, or else the justices would have been in full agreement of the proper ruling. Third, the judiciary is a political as well as legal institution. The campaign finance ruling was a product of contending political forces, had political content, and was decided by political appointees. Political thinking. Is the issue political or judicial? The Supreme Court has made a distinction between political issues, which are to be decided by elected officials, and judicial issues, which can be ruled on by judiciary. At times, however, the Supreme Court has ruled on issues that had previously left in the hands of elected officials. An example is the 2010 campaign finance ruling, in which the court held that Congress could not prevent corporations and unions from spending freely on elections. The court had previously held the Constitution from spending freely on elections. The court had previously held the Congress had the power to regulate such spending. Is the line between political questions and judicial questions therefore an artificial one? Is it a line that the court can cross whenever it chooses, and therefore a line without substantial meaning? This chapter describes the federal judiciary. Like the executive and legislative branches, the judiciary is an independent branch of the U.S. government. But unlike the other 2 branches, its top officials are not elected by the people. The judiciary is not a democratic institution, and its role is different from, and in some ways more controversial than the roles of the executive and legislative branches. This chapter explores this issue in the process of discussing the following main points. Point 1. The federal judiciary includes the Supreme Court of the United States, which functions mainly as an appellate court, Court of Appeals, which hears appeals, and District Court, which holds trials. Each state has a court system of its own, which for the most part is independent of supervision by the federal courts. Point 2. Judicial decisions are constrained by applicable constitutional law, statutory and administrative law, and precedent. Nevertheless, political factors have a major influence on judicial appointments, and decisions. Judges are political officials as well as legal ones. Point 3. The judiciary has become an increasingly powerful policy-making body in recent decades, raising the question of the judiciary's proper role in a democracy. The philosophies of judicial restraint and judicial activism provide different answers to this question. The federal judicial system. The Constitution establishes the judiciary as a separate and independent branch of the federal government. The Constitution provides for the Supreme Court of the United States, but gives Congress the power to determine the number and type of lower federal courts. I'm going to take a drink of water now. All federal judges are nominated and appointed to office by the President, subject to confirmation by a majority vote in the Senate. Unlike the office of the President, Senator, or Representative, the Constitution places no age, residency, or citizenship requirements on the office of federal judge. Nor does the Constitution require judges to have legal training, though by tradition they do. Once seated on the bench, as specified in the Constitution, they hold their offices during good behavior. This has meant, in effect, that federal judges serve until they die, or retire voluntarily. No Supreme Court justice, and only a handful of lower court judges have been removed through impeachment and conviction by Congress. The method of early removal is specified by the Constitution. Alexander Hamilton argued forcefully for the life tenure for federal judges in Federalist No. 78, responding to arguments by anti-federalists that unelected life-appointed judges would be a threat to the Republic. Hamilton argued that the judicial branch would be the weakest of the three branches, whereas congressional power rests on spending authority, the power of the purse. The presidential power rests on the control of military force, the power of the sword. Judicial power rests on what Hamilton called judgment, the reasonableness and fairness of its decisions. The best way to ensure that judicial decisions meet this standard, Hamilton claimed, is to grant life tenure to the federal judges so that they are free of all allegiances except to the rule of law. The Supreme Court of the United States. The Supreme Court of the United States is the nation's highest court. It has 9 members, the Chief Justice and 8 Associate Justices. The Chief Justice presides over the court, but has the same voting power as each of the other justices. Article 3 of the Constitution grants the Supreme Court both original and appellate jurisdiction. A court's jurisdiction is its authority to hear cases of a particular type. Original jurisdiction is the authority to be the first court to hear a case. The Supreme Court's original jurisdiction includes legal disputes involving foreign diplomats, and in cases in which the opposing parties are state governments. The court in its history has convened as a court of original jurisdiction only a few hundred times, and has rarely done so in recent decades. The Supreme Court does its most important work as an appellate court. Appellate jurisdiction is the authority to review cases that have already been heard in lower courts, and are appealed to higher courts by the losing party. These higher courts are called appeals courts, or appellate courts. Appellate courts do not retry cases. Rather, they determine whether a trial court in hearing a case has acted in accord with applicable law. The Supreme Court's appellate jurisdiction extends to cases arising under the Constitution, federal law and regulations and treaties. The court also hears appeals involving legal controversies that cross state or national boundaries. Article 3 of the Constitution gives Congress the power to create exceptions to the Supreme Court's appellate jurisdiction, whereas its original jurisdiction is unaltered by Congress. Selecting and deciding cases. The Supreme Court is the most apparent when it declares another institution's action to be unconstitutional. This power is called judicial review, was first asserted by the Supreme Court in Marbury v. Madison, 1803, when the court rebuked both Congress and the President, see Chapter 2. It is a power that the Supreme Court has used sparingly. It is usually deferred to Congress and the President when there is reasonable doubt as to whether their actions fall inside or outside the bounds of the Constitution. Another judicial review is its most dramatic power. Although judicial review is its most dramatic power, the Supreme Court's primary responsibility is to establish legal precedents that will guide the decisions of lower courts. A precedent is a judicial decision that serves as a rule for settling subsequent cases of a similar nature. Lower courts are expected to follow precedent, that is, to resolve cases in ways consistent with upper court rulings. Nearly all cases that reach the Supreme Court do so after the losing party in a lower court case requests that it hear the case. It is at least 4 of the justices agree to do so. The court issues a writ of certiorari, which is request the lower court to submit to the Supreme Court a record of the case. Each year, roughly 8,000 parties apply for certioria. But, I'm never going to get this right. Certiorari. Certiorari, we'll go with that. But the court grants certiorari to fewer than 100 cases. See figure 14.1, which you can't. The Supreme Court is most likely to grant certiorari when the U.S. government, through the Solicitor General, the high-ranking Justice Department official who serves as the government's lawyer in Supreme Court cases, requests it. When the government loses a case in a lower court, the Solicitor General decides whether to appeal it. Such cases often make up half or more of the cases the Supreme Court hears in a term. The Supreme Court seldom accepts a routine case, even if the justices believe that a lower court has made a mistake. The court's job is not to correct these errors of other courts, but to resolve substantial legal issues. The court's own guidelines say there must be compelling reasons for accepting a case, which include resolving issues that are being decided inconsistently by lower courts, correcting serious departures from accepted standards of justice, settling key questions of federal law, and reviewing lower court rulings that conflict with a Supreme Court decision. When the court does accept a case, chances are most of the justices disagree with the lower court's ruling. About 3/4 of the Supreme Court decisions reverse the lower court's judgment. During a Supreme Court hearing, the attorneys for the two sides present their oral arguments, which typically are limited to 30 minutes for each side. Each side also provides the court a written brief which contains its full argument. The oral session is followed by a judicial conference, which is attended only by the 9 justices, in which they discuss a vote on the case. The Chief Justice has the option of speaking first on the case, and can sometimes influence the decision by framing the choice in a persuasive way. Regardless, the conference's proceedings are secret, which allows the justices to speak freely about a case, and to change their positions as the discussion progresses. I think I'll do the next one with a ridiculous accent. Issuing decisions and opinions. After a case has been decided, the court issues its ruling, which consists of a decision and one or more opinions. The decision indicates which party the court supports, and by how large a margin. The most important decision of the ruling, however, is the opinion, which explains the legal basis for the decision. In the landmark Brown opinion, for instance, the court held that government-sponsored school segregation was unconstitutional because it violated the 14th Amendment provision that guarantees equal protection under the law to all citizens. This opinion became legal basis by which public schools throughout the South were ordered by lower courts to end their policy of racial segregation. Political thinking, the weakest branch. Alexander Hamilton said that the judiciary is inherently the weakest of the 3 branches of government. Does the scope and impact of Supreme Court rulings, see chapters 4 and 5, suggest that Hamilton, though correct in saying the judicial branch is weaker than the legislative or executive branches, may have understated the power of the courts? When a majority of the justices agree to the legal basis of a decision, the result is a majority opinion. In some cases, there is no majority opinion because, although a majority of the justices agree on the decision, they disagree on the legal basis for it. The result in such cases is a plurality opinion, which presents the view held by the most of justices who vote with the winning side. Another type of opinion is a concurring opinion, a separate view written by a justice who votes within the majority but disagrees with its reasoning. A final type is a dissenting opinion. In it, a justice on the losing side explains the reasons for disagreeing with the majority position. When part of the majority, the Chief Justice decides which justice will write the majority opinion. Otherwise, the senior justice in the majority picks the author. The justice who writes the court's majority opinion has responsibility to express accurately the majority's reasoning. The vote on a case is not considered final until the opinion is written and agreed upon, so give and take can occur during the writing stage. In rare instances, the writing stage has produced a change in the court's decision. In Lee v. Wiseman, 1992, a case involving prayer at a public school graduation, Justice Anthony Kennedy, originally siding with the 4 justices who said prayer was permissible. While writing the 5-4 majority opinion, Kennedy found that he could not make a persuasive case.